Welcome to Bar and Bench. Today we are in conversation with Senior Advocate Abhishek Malhotra on the online gaming bill. Welcome, sir.
So I have three questions for this interview, sir. So the first question is that the bill does not seem to make a differentiation between games of skills and games of chance. It
Right.
just seems to be banning all money, real money games without discrimination. Do you think this will present a constitutional challenge for the bill, sir? Considering Supreme Court has ruled on this many times.
No, absolutely. To my mind, it's a straight-out question of 70 years of jurisprudence, 60 to 70 years of jurisprudence being given a go-by completely through this one bill. All along, since the Chamar Bagwala cases, the Supreme Court has consciously made that distinction between games of chance and games of skill, categorically saying that games of chance do not enjoy constitutional protection, whereas games of skill do. And then, of course, it is a preponderance of skill because there is recognition that each game will have an element of chance. But is it more skill or more chance which decides whether or not there is any protection that is going to be afforded? And in the same way, Chamar Bagwala, Satyanarayanan, all of these string of decisions, and of course, more recently, the Madras High Court, Kerala High Court, and Karnataka High Court have all ruled that games of chance enjoys a separate categorization, is protectable under 19(1)(g), sorry, games of skill, protectable under 19(1)(g), and therefore is permissible. So that's one level of challenge. The other level of challenge will be under 19(1)(a), because the argument also is that the games that are games of skill don't look at it only from the point of view of existing card games like Rummy and poker and all, right? Don't look at it also from the fact of the matter that it is only fantasy right now. There are multiple other casual games that present an element of creativity. That's also creative expression, therefore protectable under 19(1)(a). So therefore, they will have to surmount these two constitutional challenges apart from, and this is something going to be new because this is how the bill has been formulated. In my mind, once you decide that the basis for protecting esports is because they represent an element of physical dexterity or mental ability or strategy or a combination of all of those, and you seek to protect social games which are played without money because they are creative, you are actually saying that you want to protect creativity and you want to protect elements of skill. If that be the case, how can you create a sub-classification only because there is betting? So there's an Article 14 violation also.
So the second shocking part of the bill, which has been disseminated for now, is that whoever is involved in it, be it the banks, doing transactions for, it's all categorized as non-cognizable offense and non-bailable. So how serious is this, sir? Is it taking it a step too far?
To my mind, yes. Look, till 2023, the government categorically took a stand, including before courts of law, that games of skill are not just protected under the law, but they're also charged to GST under a lower slab of 18% versus the others, which are 28%. Games of chance are 28%. October 2023, you bring this in the fold of 28% also. But all along, there is recognition that this is legal activity. There are news reports only 3 or 4 days ago where the GST Council is going to deliberate whether they want to increase the sin tax categories of online gaming, cigarette, liquor, luxury cars from 28 to 40%. So all along, you are expressing an intent that this is all legal activity. You are inviting and encouraging foreign investment. Everything is taken. And then suddenly there's a change, not just to say that, look, we are not going to allow this or going to excessively tax you, whatever, but we're going to outlaw it and outlaw it to the extent that there will be criminal sanctions. So I think it's very, very draconian that this is sort of happening.
So, and thirdly, there is also a constitutional question. This is in the state list, like gambling and these activities are covered in the state list, but this ban is coming through a central legislation. How do you see this? Is this a big constitutional question that needs to be answered, or
So, apart from the 3 points that I mentioned, 1920, 1914, legislative competence is also going to be an issue. And that's the reason for that is betting and gambling is a specific entry under list 2 rule entry 34, where the states have the absolute power to legislate. Right? Even when the Public Gaming Act came about in the early 1900s or late 1800s, there was a specific request made by the states to the center to enact a common legislation for the entire country. Now, the interesting part is that all along the gaming companies have been arguing before states. Whenever states have tried to regulate games of skill, the companies have said, look, Mr. State Legislature, your competence extends only to legislate on games of chance. Because it is that betting which is amounts to gambling, and gambling is games of chance, that you can regulate. So you can regulate lotteries, you can regulate casinos, you can do whatever. But you can't regulate games of skill. So now, point is, can the center regulate games of skill? Potentially, yes. And that's the reason why they had justified the amendments to the IT rules in 2023 and brought in a category of self-regulatory bodies and online verified games of skill and online gaming intermediaries and all those aspects. But to say that we are going to regulate everything that is online, whether it is esports, game, or game of skill, game of chance, combination of that, regardless of that, they've taken the power that, to my mind, they have, which is to regulate game of skill, but then they have extended it to including even games of chance, because they've outlawed everything and put it in the category of betting and gambling. If that be the case, then it is no different from the state list. And the center very clearly during the GST matter, the ALG made a statement that this is regulated by state, center has nothing to do with it. So once you've taken that stand, then how can you go back? So yeah, you're right. It's going to be a huge issue of constitution.
So one last question is that you have appeared in the 28% GST case that just concluded. Right. And immediately within a couple of weeks of the matter getting reserved, now the center has planned to ban real money gaming altogether. So what do you think will be the repercussions on that? I mean, those are on retrospective demand notices. What do you think will be the repercussion on that, sir?
No, so one, this legislation, I believe it's just also been passed by the Rajya Sabha. So it will wait a presidential assent. And assuming that the challenges that are anticipated against this are not able to succeed on getting a stay or whatever it is, then clearly there is illegality, but that illegality will only be prospective, not retrospective. So there'll be a double whammy for the industries, for the companies. One, they will necessarily have to either change their business models or close down. But once they do, there is nothing really to pay to the state, to the exchequer in the event that they lose the GST matter. But yeah, I mean, I don't know whether it will probably render the entire GST issue completely moot, because there's really nothing going to be to recover from.
That's it from me, sir. Thanks a lot for your time.
Okay. Thanks a lot.